Yes.
That reminds me of my niece. All right, the court. And I guess this is for one case. Court is calling 2024 CR 4295 State versus Luis Beltran. Can I have parties approach and announce for the record?
Yeah, I'll wait for Steve. Arlene Gay, the defendant.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third-party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that he has been, that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand?
Mhm.
All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of in the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have, yes.
Excuse me, did the court take judicial notice of the indictment in this case?
Yes,
Make its ruling, okay.
yes.
The
And
other,
then the next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph, that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right,
Did I get that right?
Yes.
Okay.
all right. So State, you want to address the issue and what and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right, so if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right, so Mr. Beltran, do you understand with the charge of an aggravated robbery case? Sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? You gonna have any questions about the court's ruling?
No, Your Honor.
All right, if there's something you don't understand, let me know, all right? And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right, so number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to, being a third party brought in here without, abstract subject matter jurisdiction. And, the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial, and if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me, you're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity? What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand?
Yes, ma'am.
Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm gonna ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff. And they're the ones that are pursuing and to prosecuting me,
Mhm.
which is they're one of third party,
Okay,
and I'm not. I don't. Third party, I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual.
Yeah,
If it's
yes.
civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bear County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You
I
understand?
understand, Your Honor.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything.
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay?
Understood.
So that will be denied.
There is a, there was, it appears to me that there was like 3 separate documents stapled together, because
Yes.
that's the way it was received.
Yes.
There is the next one, which is exhausting administrative relief.
Mhm.
My client is, not wanting to have that heard, right? It deals with ineffective assistance of counsel. Right, Mr. Beltran, that's not to be heard right now?
All right,
Okay,
and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand?
Understood.
And Ms. Gay, are you on the first-degree will?
yes, I am.
All right.
So the next document is entitled, Court Constitutional Notice,
Mhm.
and, that addresses, antitrust violations, brought upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right, the first is new discovery of antitrust violation lies brought upon the court. Elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the state bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right, so with that, I can tell you, the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Student.
Yes. So the state bar is not participating in this trial. Now, I can tell you as an attorney, your client, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying you.
Understood, Your Honor.
All right, the next one is state bars, virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the state bar hasn't gathered any evidence. State. do
I
you
think I
know-
just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false state bar, anything with regards to the state bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court, does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901. And that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding the collection of evidence. I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell, there are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment, or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases?
No, Judge.
All right. Does that address that issue for you?
Yes, ma'am.
All right. Then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, ma'am.
All right, does that address that issue?
Yes, ma'am.
I think the other issues deal on the second page, deal with the state bar, and I think the courts address that.
Okay,
The other one is the gross advertising negligence of the DA's office
okay.
and defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically, it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, ma'am.
All right. Do you have any questions about anything else?
Mm.
Okay. And then the next page, page 6, it has postscript. Is there something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial, okay?
Yes, ma'am.
All right. All right, is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No, no.
All right, is there anything that you don't understand about the jury trial process? All right, so I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, sir.
All right, so if you still want a jury trial, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right, so, counsel, you're still requesting a jury trial? All right, Norma, if you can put them on the, jury trial, please, and Ms. Galloway, if you confer
Yes.
with the defense on a jury trial date, so they're gonna get a jury trial date, okay?
Thank you, Your Honor.
Oh, you're welcome. And who's the attorney on Edward Rodriguez?
Here, Judge.
Okay. All right, if you all will come up.
Yes, Your Honor.
All right, court is calling 2025 CR 002-041 State versus Edward Rodriguez. Could I have parties announced?
Megan Galloway for the state.
Adam LaHood for the defendant, Your Honor.
And are you Mr. Rodriguez? And there are no applications?
No, Your Honor, it's a straight term.
All right. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Rodriguez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, you're charged with manufacturing and delivery of controlled substance penalty group 1, 4 to 200 grams as a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I did.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine, no applications, and this will run concurrent with 2024 CR 2941. Did you understand that to be the plea?
Yes, I did.
Defense is at the plea?
It is, Judge.
State is at the plea.
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
We have no objections, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places?
Yes, I did.
I'm sorry, in all of the places. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge. We don't need a PSI.
Anything you wish to say on behalf of your client?
Your Honor, just that he acknowledges he made a mistake. He's here owning up to it and taking responsibility, Judge.
All right, the court will find you guilty, sentence you to 5 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrent, and this will run concurrent with 2024 CR 2941. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we'll move on to 2024 CR 2941. Are you the same Edward Rodriguez who's placed on deferred adjudication in 2024 CR 2941 for the offense of injury to a disabled person with intent bodily injury on May 2nd, 2024 for a period of 6 years? All right, and did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney and understand it? All right, state.
Violation of condition number 1 on or about the 21st day of November 2024 in Bexar County, Texas. The defendant, Edward Adam Rodriguez, committed the offense of possession of a controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
True.
State.
You waive and abandon the remainders, Your Honor.
Any objections?
Objections, Judge.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court would find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It is to revoke the defendant's community supervision, adjudicate him guilty, and sentence him to 5 years in the prison
That is an understanding, Your Honor.
and run concurrent with
Yes.
the case that we just pled on, Your Honor.
All right, probation, has he done anything on probation?
Only the top evaluation.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record. All right, why were you not successful on probation?
I was actually did my classes, AA and A. Had my probation officer submit copies. And I also was the day I got arrested for my new charges. I was gonna graduate my parenting class. So, I made 2 payments. I just got a job 2 months prior to the arrest, and yeah, I did all the classes I had to. I was just about to graduate my parenting, and
I guess when probation knocked on your door for a scheduled field visit, that was shocking, wasn't it? See, and you know what? People always wonder why field visits, because you know what? You really don't know if someone's doing well until you get a chance to see them in their homes or sit down and have a meal with them. All right, the court is going to follow your agreement. Are you waiving your right to appeal?
Yes.
The court is going to follow your agreement, find you guilty, revoke, sentence you to 5 years in the prison. This is run concurrent with 2025 CR 002041. There's to be no contact with David Rodriguez. And I'll suggest the therapeutic community. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, You do not have the court's permission to appeal. Because this is a felony conviction. Just one moment. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. You need to start asking yourself. You need to start asking yourself what you want to do with the rest of your life, because what's going to end up happening is you're going to wake up and find that you spent the majority of your life in somebody's prison or jail. If you don't change, that's what's going to end up happening. If you continue on the path that you're on, people who sell drugs, one of two things going to end up happening. One, you may make some money, but at the end of the day, you're not going to know where it went. Or somebody's going to try to rob you to take your drugs and your money. Or somebody's going to be upset with you because you let somebody rob you and take the drugs and they want their money. Do you understand? Do better. Good luck to you. Oh, thank you. God bless you too.
Thank you, Your Honor. May I be excused?
Yes.
Thank you, Judge.
Judge, and so upon trial date will be July 22nd.
All right, July 22nd. All right, we'll see you all for jury trial then. Okay. Thank you.
No, not yet. Yeah, that can happen. That's good.
Let's see on Rogelio Alfonso Elizondo, if they can come up.
Just so the court's aware, I was out of town this morning. I let the court know, so
Problem.
that's why I was late.
All right, so today is plea deadline date. Does he want a jury trial? What are we doing?
So I conferred with the state on this. Last setting, we had, I filed a motion to substitute, which was granted.
Mhm.
I had an opportunity to review the discovery, Your Honor, and noticed that I was missing the dash cam for the arresting officer, the person that actually stopped him. I let the ADAs know that, and they've requested that via email. I'd like the court, if possible, to give me 2 weeks so that they can get that discovery. I don't think it's gonna take that long, but so I can review it before we proceed.
All right, Norma. I need a 2-week reset. And it's a plea deadline date.
June 26th. Judge.
All right, June 26th.
Thank you, Judge.
All right, once you sign the reset form, your excuse. You're welcome. Rebecca Davis. Hello.
Hi.
All right, so have you conferred with the state?
Yes, I have, and they are not opposed to the occupational license. She is currently complying with her conditions, which is to have the interlock device. So she has that on her vehicle.
Okay, we'll need to go on the record.
Okay.
All right. Could I have someone from the state? The court is calling 2025 CR 003154, which is the trial court cause number, and 2025 CI 11673, which is the civil request for the occupational driver's license. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Arlene Kay from Miss Davis.
And are you Ms. Davis? All right, so there's a request for an occupational license. And you may proceed.
Your Honor, my client filed this pro se, and I found out that I was appointed to assist her today. So I have gone over the document. We've talked about it. She does have the interlock device on her vehicle. This is an essential need. She is starting a job on the 26th of this month. She is living in the SOBA facility, rehabilitation facility.
Mhm.
They do allow vehicles. And, you know, besides the interlock device, she is tested for drugs and alcohol routinely while she is there. She wants to start her job. Also, she will need to drive to get to not only in the future doctor's appointments, but also appointments related to her probation. And then we have the household going to HEB, getting gas, things like that, that she's asking to go to. I believe that the statute allows to drive up to 12 hours a day. I think she put from 6 to 6 a.m. to 6 p.m. now.
Well, what I can tell you all, and let's go off the record. Okay, this is what I need that's not in this document. I don't have any proof that she has insurance. So if we can have that in the document.
She has her SR 22 with her.
So if you want to make copies of that,
Okay.
or is that your copy?
Yeah.
I will have my interlock, my driver's record,
That's what all needs to be here. So,
at least are copies, so,
Okay.
and my treatment, presence of treatment letter and my actual filing.
all right, State, have you had a chance to review those?
I believe my co-counsel has,
Yes, ma'am.
and we have no objection, Your Honor.
All right, so that's what I would need. And also, there is a section in here that they want you to check off the times that she would need to be driving. So if y'all could go through that document or make a copy of the document, because technically it's filed. And if you all can make a copy of the document and put in what you need to put in.
Okay. And Your Honor, do you want these attached to
Yes.
it? So I can get it and just put first amended
Yes,
and attach proof, and then
so I'll need the proof of ignition interlock, the proof of insurance, and she needs to put in what time she's asking to be allowed to drive.
I'll talk to her about that, because 6 to 6 sometimes jobs
Okay,
may be a little difficult.
all right, so once you all do that, you can come back.
Okay, great.
Thank you. Thank you.
Your Honor.
Yes,
She did not include it in the order.
she did not do what?
Include an order, because the form didn't have an order. And she didn't know what an order is.
Okay.
So whatever we do today, I'm gonna have to go back to my office.
Well, I
type up
tell you
an
what,
order.
if you'll type it up, but I am going to be gone next week at a CLE that I have to speak at, but I'll be here tomorrow.
Yeah, I can type it up and bring it tomorrow.
Okay,
Okay.
all right, just bring it and I'll take care of it. Thank you, and continue with the good work, okay?
Yes, ma'am. Thank
All right. Who's here on Omar Herrera?
Right here.
And then after Omar Herrera, oh, there are two. And Vashawn, this is an application. All right, the court is calling 2025 CR 0033736 and 2025 CR 0038886 State versus Omar Herrera. Can I have parties announced?
Albert Chidas for Mr. Herrera.
And are you Mr. Herrera?
See,
Yes.
All right, we have an interpreter here today. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record, please.
Pamela Payan. Payan.
Mr. Herrera, all of these documents are in English. Were those documents explained to you in Spanish?
Sí.
Yes.
And counsel, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
Yes, I did.
And were you able to explain these documents to your client in Spanish?
Yes, I was, Judge.
All right. Counsel, have you received all discovery and did you review it with your client?
I did.
And
I
each
did.
cause number? I'm
I
sorry.
did and I did.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Herrera, in each cause number, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Sí.
Yes.
In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Sí.
Yes.
Counsel, in each cause number, do you waive the reading of the indictment?
We do, Your Honor.
State, in each cause number, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Herrera, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Sí.
Yes.
In each cause number, you're charged with unauthorized use of a vehicle. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
All right, off the record for a moment. Counsel, on this one, he hasn't checked the box. All right, we're back on the record. And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, and yes.
Mr. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
No.
Anyone promised you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Sí.
Yes.
Are you a US citizen?
Yes.
All right, you have to wait for her to finish translating. Either we're going to use the translator or we're not. Do you understand?
Sí.
Yes.
Do you want to use the translator?
Sí.
Yes.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargains in each of these cause numbers with your attorney? Did you understand it?
Sí.
Yes.
According to the plea bargaining agreement, your punishment is to be assessed at 2 years in the state jail facility. The state is recommending community supervision. The cause numbers will run concurrently, and there's to be restitution, if any, to the complainants in each cause number. Did you understand that to be your plea?
Sí.
Yes.
Defense, is that the plea?
It is, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Sí.
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sí.
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. Did you understand that was a recommendation from the state and the court does not have to follow those recommendations?
Sí.
Yes.
Then in cause number 2025 CR 0033736, how do you plead? Guilty, not guilty, or no contest?
No me pongo.
No contest.
And cause number 2025 CR 0038886, how do you plead? Guilty, not guilty, or no contest?
No me pongo.
No contest.
State any evidence to support the defendant's plea.
In each case contained in exhibit one and attachments.
Any objections?
No objection, Judge.
All right, state you may be excused. Did you review the waiver and consent to stipulations in each of these cases?
Yes.
Did you understand it and sign it in all the appropriate places?
Sí.
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Sí.
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence state's exhibit 1 and attachments, and the court will review the same.
Okay.
That's how you say okay in Spanish. Is it okay?
Sí.
It's common that they say okay, but usually when people say okay in Spanish, just está bien, but okay is accepted.
Está bien.
Yes.
Before the year is over, I'm gonna learn how to say okay in every language. All right, after reviewing state's exhibits 1 and attachments and each cause number, the court will find there was sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Nothing other than he's ready to start probation and he hopes to complete it as quickly as possible.
All right, do you have any children?
Sí.
Yes.
What are their ages?
8, 5 y 4.
8, 5, and 4.
I knew those numbers. All right, do they stay with you?
Sí, hablo con ellos, pero no están conmigo.
Well, I talked to them, but they are not with me at the time.
All right, do you buy,
They're with their mother.
all right, do you buy them gifts?
Sí.
Yes.
All right, are they boys or girls?
2 hombres y una mujer.
2 boys and a girl.
Okay. Now with your boys and your girl, I'm gonna say the girl. When she's old enough to start driving, are you gonna get her a car?
Sí.
Yes.
All right. So let's say she gets old enough, you get her a vehicle, right? She's gonna be excited about it. You're probably gonna put a bow on it. Who knows? Maybe it'd be for her 16th birthday, right? What type of car would you get her?
Un bonito que le gustará a ella.
A nice one that she would like.
All right. And I'm sure as a dad, you'll be proud that you got that for your daughter and that she's riding around in it, right?
Sí, claro.
Yes, of course.
And I'm sure your daughter is going to be a great daughter, so she's probably going to have a job or something too, right?
Yes.
Yes.
Esperemos que sí.
but still gonna be in school and graduate, right?
Yes, of course.
So let's say that she has a job and it's a nice job and she's working while she's still in school, getting great grades. And she goes to her job and they have her working in the back, right? She parks her car in the front. And let's say it's during the summertime, and usually teenagers, they have them working late in the summertime. And let's say she gets off of work at 10 p.m. and it's dark outside, right? And she comes out and her car is not there. And she's calling her dad. She's like, I know I parked it here, but it's not here. And she calls you and you come because you're still thinking maybe she parked it in the wrong place, right? And you find out that no, her car is gone. Somebody took her car. And then let's say you call the police and you discover her car and the steering column is damaged. Somebody maybe has been smoking marijuana in the vehicle, so you know it'll never be the same, right?
Yes.
So how would you feel about the person who did that to your baby girl?
Upset. Very upset.
That's what you've been doing to somebody else. They come out, their vehicle is gone, and that's what you've been doing.
Sí entiendo eso, que yo lo mataba manejando, pero yo no fui la persona como que hizo eso exactamente, que me lo robé. Digo, yo no fui la persona que exactamente yo lo tomé de la persona.
Well, it's not, I didn't do exactly that. It's not like I took it from the person.
Yo sí estaba manejando, yo estaba consciente pues, que no era mío.
I was driving though,
Estaba consciente que no era mío. Sí.
and I was aware that it was not.
Pero no, como así, que yo fui a robármelos, a abrirlos, no, yo no hago eso.
But
Oh,
it's
no.
not,
There was marijuana in the car, but continue, I'm sorry.
but it's not like I went and I stole it and took it and opened it. It was not like that.
Let me ask you this. Let's assume this person steals your daughter's car. And they're before a judge and they're like, no, it's not like I stole the car or anything, but I was driving it. And then guess what ends up happening? They have another car that they're accused of stealing. What would you say to them? If you're in the audience, what would you say to them? And you're just listening.
No, pues están mal.
Well, that it's bad,
Hicieron mal, pues no está bien lo que están haciendo.
that they did something wrong and what they're doing is not right.
And see, the reason why I asked you that is because what are the chances in somebody's lifetime that they drive two different stolen cars, saying they didn't know they were stolen?
Pues, como le digo, pues por favor, no está bien, yo sé que no está bien esto, pero pues espero que todo cambie, quiero ser una mejor persona para no cometer los mismos errores que he cometido.
Well, how do I say this? I don't know. It was a mistake.
No,
I
I'm sorry, go, I'm sorry.
don't know if it was a mistake. I'm trying to change so I don't commit the same mistakes again.
All right, these are not mistakes, these are choices. Because who is Angel Torres Casas?
I don't know him.
They say he was in the car with you. Maybe I'm mispronouncing his last name. It's Quezas.
I don't recall that name.
All right, and then who is Vivian Ortega?
Vivian.
Ella se me hace que viene siendo una hermana de una amiga mía, me parece. De una amiga mía.
She's friend of a friend of mine, I think.
Vivian, right?
Vivian?
Yes.
Parece que es.
I think so.
And who is Christy Jimenez?
No,
I don't know her.
I'm sorry, Christy Jimenez Friday.
no.
All right, and who is Regina Ortega?
Ella es la amiga que está en común con la primera que me preguntó.
She's the friend that I have in common with the first one you asked about.
Okay. And are you employed?
Ahorita está por empezar.
Right now, I'm just starting.
Estoy empezando a trabajar. que estoy pagando el bono y lo voy a pagar el provecho, pues
I have to pay for the bond and also probation.
voy a pagar.
All right, this is what the court is gonna do. And cause number 2025 CR 0033736. As previously stated, the court is finding you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 3 years. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. No employment as a home health care provider or with minors. This is the run concurrent with 2025 CR 003886. Restitution, if any, to George Torres. There's to be no contact with Vivian Ortega, Christie, Kristie Jimenez with a J, Friday, Regina Ortega. There's going to be 100 hours of community service restitution. I'm going to order parenting classes. Once he completes that, the parenting classes will be deemed satisfied. Field visits 1 time per month for 3 months. And that cause number, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Sí.
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what a weapon or ammunition is, you'll need to speak to an attorney. And cause number 2025 CR 003886, the court is finding you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 3 years. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. No employment as a home health care provider or with minors. This will run concurrent with 2025 CR 003736. Restitution, if any, to Jared, JARRED, Elias McGarity. There's to be no contact with Angel Torres. The last name is QUEZAS. There's to be 100 hours of community service restitution. I'm going to order the theft course. Once he completes the theft course, the community service hours will be deemed satisfied, and field visits 1 time for 3 months. Probation, is there anything else that's needed? And that cost number, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Sí.
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sí.
Yes.
All right, we can go off the record. You're gonna have to make better choices. What you did, those were not mistakes. Those were horrible choices. You're a grown man, you're an adult, you're supposed to be setting an example for your children. You understand?
Sí, sí.
All right.
Yes.
Everyone wants you to be successful on this probation. If I didn't think you could complete it, I would tell them I would not follow this agreement. So if there are any issues, let your probation officer know about it. If you feel they're not addressing it and I'm here, you can still come back here, okay?
Very, adiós.
Esteban.
Muchas gracias.
De nada.
Thank you.
You're welcome.
Listo.
Thank you, Judge.
Thank you. Deputy Laura, one day I'm gonna shock you all. I'm gonna come in here, I'm gonna have done Rosetta Stone, and I'm just gonna be rolling R's and speaking the language. I know. You know, there's a girl, what is her name? I can't think of her name right now, but she lives in Korea, speaks fluent Korean. And I'm just like, wow. All right, let me put this in here just a second.
Is it gonna continue with the pension? And you're an interpreter, right? What's his?
Judge, the bench trial tomorrow at 9.
Can you call the attorney and see what time,
Just check if you give us the time so we have someone here.
you know, what time the state defense will have their witnesses? Because I know their approval of one having, to appear by Zoom.
In the middle of our federal sentencing.
Okay, that's fine. If you
All
can
right.
just send the email or call us, so
Yeah.
we just know the time and we have it on the log.
Yes.
Tomorrow. Okay, thank you.
And I promise you, I will do better and allow you to repeat what you're saying. But he started speaking to me in English, so it
It
became a
happens.
conversation.
Yeah. Oh. I can tell, well, Maria's not here right now. I can tell, I'll tell her. Yes.
Let her know that you need it. That is just your sister. Kat.
Yes.
Yes,
I know.
she's the only.
So it's not me. Okay, I'll let her know. Okay, thank you.
You know, Start Tuesday. Also.
Who is here on Matthew Rendon? Hello.
Afternoon.
Oh, afternoon. How are you doing today?
Nervous, but here we are.
Hey. All right. The court is calling 2024 CR 2339D State versus Matthew Rendon. Can I have parties announced?
Megan Galloway for the state.
Victoria Cruz on behalf of Raymond Martinez for the defense.
All right, and are you Mr. Matthew Rendon?
Yes, ma'am.
All right, do you have any objections to this attorney standing in?
No, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, defense is satisfied.
All right, court will find that the state is in compliance with discovery. Mr. Rendon, did you review the document entitled Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we move to proceed on count 1 and waive and abandon count 2.
No objection from defense.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right, you're charged with aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rendon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine. If the court finds that a deadly weapon was used, there's going to be an affirmative finding of deadly weapon. The state recommends deferred adjudication, and there's restitution, if any, to Oscar Del Fierro. Fierro?
Yes, Your Honor. Yes,
All right. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Oscar Del Fierro, Anthony Cochran, Richard Campos, and the hostility management course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead to count one? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offer states one in attachment.
No objection from defense.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right. Are you currently employed?
Yes.
What do you do?
My family has businesses. I do stocks on the side.
You say
Mostly-
stocks?
Yeah, like stock market. I'm an investor.
Oh, okay.
I do a lot of entrepreneurship. It's
Okay.
that category of work.
How's stock investment going?
I don't like to get political with it all.
No, no,
It
no.
affects it, but it's good. I make good percentages yearly. Good money.
No, I asked that. I have friends who do the stock market and they're always coming to me and I'm like, don't get married to the stock. Don't marry it.
It's a lot of discipline.
Oh, it is. All right. Do you have any children?
Yes, ma'am.
And what are their ages?
I have a 4-year-old son and a 3-year-old daughter.
Okay. All right, this is what the court will do. The court is going to sentence you to 5 years deferred adjudication. There's an affirmative finding of deadly weapon. There's to be regular reporting by Zoom or in person, regular random UAs, $2,000 fine probated. There's to be restitution, if any, to Oscar Del Fierro. State, when do y'all want the restitution hearing set? All right, can I have 30 days for a restitution setting, please?
Yes.
Sure. And it may be a restitution amount that they agree on, but I've learned that when you don't set a restitution hearing, it just floats out there.
Yes.
And so I want you to be able to know what the amount is.
Judge, if you give me just a second, I'm looking up another court paper for Megan.
Okay.
I'm just trying to get it wiped up.
Oh, no problem. All right, while they're doing that, I'll continue. So there's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service will be deemed satisfied. People always wonder, why do you order parenting classes? And the reason why I do it is because when people are making these choices, they need to think about their children as well. What would happen if I go to prison? And they're not really thinking about that. They're in the heat of the moment. And let me do this. There's going to be parenting classes, 100 hours deducted for the parenting classes. And then I'm going to order the hostility management course that was recommended. And then once you complete that, the remaining 100 hours will be deemed satisfied.
Thank you, Your Honor.
There's to be no contact with Oscar Del Furio, Anthony Cochran, and Richard Campos. And there is to be proof of employment within 30 days, no employment as a home health care provider or with minors. Probation, is there anything? Thank you. Field visits 1 time per month for 5 months. Anything else, probation? Is there anything else you need from the court in order to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Do we have a date?
July 24th.
All right, so what's going to happen on July 24th? We'll be back here, and that's for us to get an amount of restitution that is owed, and your attorney will have a chance to either object to that amount or agree to that amount. Do you understand?
Yes, ma'am.
So let me explain something to you. When people bring out guns, guess what? If you end up firing it and it ends up hitting someone, there's no turning back from that. You understand? So you're going to have to start thinking and putting your children at the forefront of your thoughts in everything you do, because everything that you do ultimately ends up impacting them. If you go to jail, even if you're in jail for 30 days, getting a bond, it's where's daddy. If you end up going to prison, it's where's daddy. And then that snowballs other thing, because sometimes you have women who will wait for you after you get out of prison. Sometimes they don't. And you know what that means? That means that somebody else that you don't know is raising your child.
Yes.
All right. If you need anything, let probation know. If you feel they're not addressing it, you can always come back to the court. Okay.
Thank
All right. Good luck to you.
May we be excused, Your Honor?
Yes.
Thank you.
Let me put this in the system. Everything must go in Odyssey now, and Odyssey is slower than my typing.
Figure out working on 2 more, please.
Okay. Yes.
Your Honor, I believe, somebody did an order.
Oh, that would be probably, the greatest staff attorney on the
Right.
planet, Barbara
Yes.
Paulison.
Yes, she did an order.
I probably shouldn't say that because then somebody's gonna take her away.
Yes, you don't want that. I made one change to it. It says probation for, it should be 8 years. So I
Mhm.
just made that correction.
Okay.
I looked at it and the court wanted me to put in the amended motion, the hours,
Mhm.
but Ms. Paulson put this paragraph in.
Oh, awesome.
That says because it's a certain type,
Mhm.
that she's not restricted to hours.
Okay, let me
She
look at
put
that and
the
see.
code section.
All right, I'll see if I'll approve that.
Okay. And we did make those corrections and we listed the essential needs more in detail. And the attachments are attached.
All right. Norma,
Yes.
I have Rodriguez Luna for tomorrow. Is he in custody?
Yes.
All right.
No, what is he?
Procardo Daniel Rodriguez Luna. All right, your case is gonna have to be recalled tomorrow. Your attorney is actually in federal court and they just gave us notice of that now. Come forward. I'm sorry. No, go back. I'm sorry. The deputies are in charge of security.
Yeah, my bad.
All right. I'm sorry, Deputy Laura, forgive me.
Can't save you.
You're trying to save me. I'm gonna be in a Lifetime movie with a law named after me.
Hey,
Hi. Yes.
I was just wondering if getting you attorney. I've been contacting them, they haven't.
Who's your attorney?
Robert Vargas, judge, and he'll be here tomorrow for the
Gilbert.
first trial.
Gilbert Campos? Gilbert Campos?
Gilbert Campos?
Yes.
No.
That's not it? Oh.
Robert
Robert,
Vargas.
Robert Vargas?
All right, so this is what we're gonna do. Your attorney has said that he will be here tomorrow. So you be here tomorrow
Oh.
and we're gonna build that bridge when we get to it, okay?
Because this is my third time showing, he hasn't shown up or taken any of my calls. I called him, left messages before. There's probably
Okay,
a
so,
voicemail.
all right, so here's the thing. I really don't like for people to talk about people when they're not here, right? Because just wait for tomorrow. I have it on the docket sheet that he knows to be here tomorrow. And we're gonna have you here tomorrow at 9 a.m.
Okay.
Of course, if we have another one of these historic storms, I will give people leeway because I want people to arrive here safely.
Gotcha.
So we'll have you come back here tomorrow, you sign the reset form, and we're gonna let you two meet and talk, okay?
Thank you.
All right.
Just one other.
Yes.
If I can get like a note that's saying that I have to be here tomorrow.
Oh, she's gonna give you a reset form and it's gonna show that
Then
you're
he's
required to be here.
probably firing me, but tomorrow again.
Tell them you,
Yeah, I have good reason, but I know.
tell them you have to be here. You're not
That's the
trying to.
policy, they need a letter from it.
No, let me just tell you, when you have the reset form, it will show the 187th on it and everything.
Okay, thank you so much.
And they can always call the court and the court is gonna say he's scheduled to be here tomorrow at 9.
Okay,
All right.
that's all I. Thank you so much.
Thank you so much. Yes,
Robert Payne, is that where it says defendant?
Arlene.
No.
He's been here since this morning.
I think it's the second paragraph from the bottom.
All right, let me read. Yeah, she is, and she has the ignition in her lock, right? And
we
you
put
have,
we put this.
you've attached it?
Contract there. We put the SR 22 that's already with the state
Okay,
and
awesome. Then what I will do is I will sign it. Because I know sometimes when people do these pro se, they don't have everything in it.
yeah, the DPS website fails to say, tell them they need an order. So to get it certified, I'm gonna have to go. She needs a notary certified.
It would have to be down. No, it will keep the.
In civil court, I go and take the order,
Correct,
so I can go take this order.
correct. It has to be done by the
Okay.
pro se person.
Yes, I'll walk her over there. So I'll take all of this and I'm gonna go to the civil side and take all of this. Okay, thank you.
You're welcome. And Norma, you said Beltran is scheduled for jury trial July 22nd?
Yes, ma'am. Yeah.
You're gonna come off well, because they're gonna be saying, she tried to tell us. And you know what the title of the movie would probably be? Because she wouldn't listen. The Judge Boyd story.
An email.
Okay, just give me a second. Let me put this in the system. And you know, mom always says, well, you listen to Deputy Laura, she's in charge of your security. So you know what? Starting at 3:12 p.m., which is right now today, whatever you say goes.
Judge.
I know. If you tell me to leave right now, you know what I'm gonna do? No questions asked. You're all gonna look up. Nobody's gonna be sitting here. Can I see the file on there? Is he able to be here tomorrow? Locke?
I don't know. Who is she? You want me to check?
Yes.
You can call. You can call his office.
Yeah, this. Yeah. Yeah, it's like. Big here.
All right, Umberto Lira? Umberto Lira? Norma,
Yes, ma'am.
where's Umberto Lira?
Oh, you just left, Judge? I gave
Oh,
him
you
the
gave him the reset?
Yes, ma'am.
Okay. Who's here on Jordan Armstead?
We're ready.
Is there an application?
Yes, Judge.
Okay. Oh, come forward.
Yes.
Make sure you speak about it to the court reporter.
All right, the court is calling 2025 CR. Just 1 second.
Be done. Oh, hi. You probably just put it back.
I want to make sure I put this correctly.
That was it. Is that- Yes, it was.
Did they get new signs for each court, the gold plaque?
Yes, they did. And they misspelled my name outside. They spelled it STEPHEN. No, STEPENIE, 3
No.
E's. Yeah. All right, the court is calling 2025 CR 003910 State versus Jordan Armstead. Could I have parties announced?
Megan Galloway for the state.
Joseph Stateson for defendant.
And are you Mr. Armstead? All right, you're gonna need to speak up.
Yes, ma'am.
All right, I know you have some bass in your voice. The court reporter needs to hear it so I can hear it, okay? All right, counsel. Have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Armstead, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Judge, we need to proceed on count 1 and waive count 2.
Any objections?
None.
All right, and did you review the court admonishments?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count 1, you're charged with unauthorized use of a vehicle? That's a state jail felony.
Yes.
The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes,
Wow.
ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Armstead, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 1. There's a $0 fine. State recommends deferred adjudication. There is restitution to censor, or is it sincere? Sinclair, it's,
I think it's, yeah, it's not with an E. The last one is it's an R in the indictment. It's
all right, so it's spelled SINCER, Mendoza, or is this Mendoza? Just once. All right, Mendoza, and the amount of $1,200. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be 200 hours community service restitution, top evaluation, no contact with Sincere, Mendoza, and a life skills course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Your Honor, the state offers states 1 an attachment, and then I do a couple of things I need to address.
Yes.
Very briefly. So in the paperwork, that is the agreement. However, I failed to include that the state is taking into consideration a misdemeanor case. That clause number is 2025 DC 001622.
Any objection to the court adding that cause number to the plea paperwork?
No, Your Honor, and I'm holding on to those documents. It's originated at a County Court 12, so my understanding is I'm going to hold on to these and approach
Yes.
County Court 12.
All right, thank you. All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, and I have something to add at the appropriate time.
Yes.
Your Honor, I asked my client to do some upfront classes. I'm appointed. He was found indigent. He's unemployed. He's looking for work. He managed to take 1 class conflict-wise. I provided that to ADA Ms. Galloway. I would ask that if you could, it's not the same class that the state was asking for life skills, but I was asking if you can give him credit towards maybe some community service hours if he provides that class certificate to probation. He had nothing to do with the robbery of Miss Mendoza
Yeah, I see. They said it was
or Hispanic.
yes. And they described him as Edgar's
Correct.
because of the haircut?
All of them had the Edgar haircut. Correct. Clearly,
Okay.
he does not. And
No.
he regrets picking the keys up in the parking lot, but we agreed to a fixed amount on restitution. In the event that the complainant was seeking additional restitution, we would ask for restitution here. And I discussed this with Ms. Galloway. I believe that the complainant was going to seek wear and tear damages and not collision damages. So we agreed to a number. There's no contesting the 1,200, but if there's something past the 1,200, we would want a restitution hearing.
All right. So how old are you?
26.
You should know better than pick up a key fob and start trying to see which part works to. You should have just turned that key in, and who knows, the person who owns the vehicle, maybe they will give you some kind of reward for finding their vehicle. Now instead, You have this felony that you're charged with. You know better, right?
Yes.
And you should know better if you're wearing that jersey. Yeah, I mean, that's Muhammad Ali. Did you see him stealing? And the times were surely hard for him. So if you're gonna wear that, you need to represent what he represented. You understand? All right, how far did you go in school?
Okay.
Did you graduate?
Yes.
All right, what are you planning on doing with the rest of your life?
Like, professional basketball,
With who?
like for semi-protein, San Antonio Powerhouse,
All right, so what position do you play?
shooting guard.
And are you making your shots? Mm-hmm.
Yes.
All right. And how are your free throws? Oh, please. He said, are they like money? Or are they like Shaq's free throws? Maybe, maybe not.
Maybe.
Okay. I never understood why would Shaquille O'Neal, they didn't let him know you're gonna get fouled a lot, so we need to work on these free throws.
He got better through the years.
But you know what somebody said with his free throws, it's sort of like if you were trying to throw maybe a free throw with a golf ball.
Oh, right.
That makes it very difficult, you
Correct.
know, if the ball is so small in comparison to your hands. All right. Does he have any prior history?
No prior history. If the state had said no initially to pretrial interrogation. But what essentially is happening now is if we give the state more time to look at the case, maybe have more time to do some process. We come back to a court setting, we may offer a interrogation program. Maybe they don't. But maybe in the best interest to contact the setting.
I'll tell you what I can do is I can set this for sentencing.
Mhm.
And the plea has already been taken. I've accepted your plea. So I can set it for sentencing. They'll have a chance to look at things.
And if things don't change, you're still getting the same deal. If things change, maybe it could be a little bit. You okay with that?
All right, so we're back on the record. The court is finding there's sufficient evidence to find you guilty. The court is deferring finding of guilt as you applied for deferred adjudication. Ms. Galloway, how much time do you need, you think?
Probably just 2 weeks. I need to just call the detective and speak.
All right, do you want to set it maybe,
Thursdays and Fridays are my best dates.
you want to do July 10th, July 17th?
The 10th will work for me, and if things change, I'll reach out to Mr. Stateson so that we could get what we need to get in for our court date.
All right. And then Mr. Stetson, if you can hand me back the,
Certificate of appeal.
yes,
Yes, Judge.
thank you. All right, so we'll be back on July 10th.
Thank you, Judge. Have a seat.
You're welcome. All right, Norma, if you'll give him a July 10th reset date. And then the next, Mr. Outlaw.
Okay.
All right, let me just put this in here real quick. All right, are there any applications
No, Your Honor.
and 3 cases?
Yes, Your Honor.
Okay. Court is calling 2025 CR 002531, 2025 CR 002532, 2025 CR 0023, I'm sorry, 2025 CR 002534, State versus Eddie Law Outlaw. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Martin Guerra, attorney for Eddie Outlaw.
And are you Mr. Outlaw?
Yes.
Counsel, in each cause number, have you received all discovery and did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Outlaw, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State in the cause number ending in 3-1, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the enhancement paragraph.
No objections.
And in count ending in 3-2, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving that enhancement paragraph also.
No objections.
And in count ending in 3-4, are you proceeding on the indictment as presented?
Waiving the enhancement paragraph.
No objections.
In each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In each cause number, you're charged with aggravated robbery. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state calls, and the right to remain silent. Did you understand by entering these pleas, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each one of these cause numbers?
Yes.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Outlaw, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
In each cause number, punishment is to be assessed at 16 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. The cause numbers were run concurrently with each other. And the state will take in consideration 2025 CC 006439. Did you understand that to be the plea in each cause number?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then in cause number 2025 CR 002531, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2025 CR 002532, how do you plead?
No contest.
And cause number 2025 CR 002534, how do you plead?
No contest.
State any evidence to support the defendant's plea?
Yes, Your Honor. In each of the cases, state exhibit number 1 with all of its attachments.
No objections.
In each cause number, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would calling the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he accepts responsibility for his actions. These were terrible mistakes. For many years now, he has been dealing with a drug addiction. And I think it's safe to say had he not had that addiction, these offenses would not have taken place. Because of that, we are asking if you could put in the judgment that he be placed in a therapeutic community.
All right, the court is going to sentence you to 16 years in the prison. There's a $2,000 fine. Time and money will run concurrent. There's an affirmative finding of deadly weapon. And this is in cause number 2025 CR 002531. This will run concurrent with 2025 CR 002532, 2025 CR 2534, taking consideration number 2025 CC 006439. And the court will request the therapeutic community. And cause number 2025 CR 002532. Court is finding you guilty. The court is sentencing you to 16 years in the prison. Give you credit for any time served. There's a $2,000 fine. Time and money to run concurrently. There's an affirmative finding of deadly weapon. This will run concurrent with 2025 CR 002534, 2025 CR 002531, taking consideration 2025 CC 006439. Court will request the therapeutic community. And cause number 2025 CR 002534. Court is finding you guilty. The court will sentence you to 16 years in the prison. Give you credit for any time served. There's a $2,000 fine. Time and money to run concurrently. There's an affirmative finding of deadly weapon. This will run concurrent with 2025 CR 002532, 2025 CR 002531. Take in consideration 2025 CC 006439 and request the therapeutic community. Is there anything else with regards to sentencing?
No, you.
All right, in each cause number, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, sir.
All right, in each of these cause numbers, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Oh, I'm so sorry. And in 2025 CR 002534, again, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
And because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, so here's the thing. You're gonna have to start making better decisions. Otherwise, you're gonna spend the rest of your life in prison. Do you understand?
Yes, sir.
And if you have a drug or alcohol problem, there are plenty of places that are free in San Antonio that will help you. When you're released from the prison, if you cannot find a place that will help you, if I'm still here, you can come back here and I will find a place for you. Do you understand?
Yes. Opiates.
Opiates?
Yes, sir.
Well, they have locations that handle opiates and alcohol as well, okay?
Yes, sir.
So you're gonna have to get control of that. Otherwise, you're gonna spend a lot of time at the prison. You understand? All right, good luck to you, okay?
Thank you, Judge. Here's the dismiss.
Okay. Okay, so here's the thing.
Let me just,
Some misdemeanor courts don't want us to sign these, so they have to sign them. Okay,
Well, I can run it over.
all right, thank you. All right, do we have anyone else on the docket?
That's it, Judge.
All right, yes. All right, we'll be back tomorrow for bench trial.